Hey everyone, we're going to look at the court system today. Understand that whenever we look at the politics of justice, the court system is a political institution. You can look at it from the perspective of a party direction, Democrat or Republican, or political in terms of who gets what, when, where, and how. But understand that when you look at the court system, either at the federal level or at the state level, we're talking about those bodies that have to make some important policy decisions in this country. And here is a variety of court terms that you need to know. And in the United States, we are a sue-happy country. The reason why we have so many lawsuits in this country is because we have so many attorneys and lawyers in this country. Typically, we have about 15 million civil court cases that come up every single year. That means we are going to end up with an overcrowded court system. And you also see why we have so many lawsuits. There are so many different directions we can go with a lawsuit. Every election season, you may hear about tort reform. And really what we're talking about is making sure that we cap awards for pain and suffering as a judgment in a court case. Those that like the judgments, of course, are the attorneys. Those who want tort reform are the insurance companies because they don't want to pay out. We do have national supremacy in this country, where the supremacy clause says that the federal constitution supersedes the state constitutions, but we do have something also called Judicial Federalism, which refers to the state's authority to interpret their own constitution in their court system. With judicial federalism, we've nationalized the Bill of Rights since the 1920s. The Supreme Court has said the states and all of their subdivisions are bound by the Bill of Rights. So what we have in the first 10 amendments in our Constitution applies to the states as well. And here are some examples of how we've applied the Bill of Rights and how we've incorporated them into our 14th Amendment, which gives due process under the law. Here we have some descriptions of our court system through the structure of our court systems in the state. This you can also find in the text. Many of you might have had some dealings at this level right here. Hopefully not here, but you probably have had some sort of form of traffic court over the years. There are several ways a judge at the state level becomes a judge, and that's through appointment, interim appointment, elections, and appointments through retention. When you have an appointment, you remove the selection of judges from party politics. The interim only takes place when a judgeship is vacant. When you have an election, incumbent judges, just like anybody who's running for office, has a huge advantage because they have name recognition. Then also you have an appointment where somebody is appointed, and then you run basically against yourself in an election. So you might see in Illinois an appointment retention election where you'll see a judge's name on a ballot, and what you have to do is vote yes or no as to whether you want to keep that judge in that seat. Here are the methods of selecting state court justices and judges at the appellate level. And then here you have it where it's at a major state trial court. Notice that we have a combination in Illinois when it comes to the appointment retention election. In other cases, we have it where somebody gets elected and runs against somebody from another political party. There are several sectors that contribute to judicial campaigns. So there is money involved in the election of judges. Then finally, you have what we might call the decision-making process. And what's interesting here is that you look up something called judicial activism versus judicial restraint. And you find that there's a recent trend towards activism. Judicial activism is where you pretty much make your decision on a certain case because of the changes that are occurring in society. Judicial restraint looks at past cases, and you make your decisions based on precedent. You can be conservative or liberal and be an activist at the same time. Typically, if you listen to people, they'll say that liberals tend to be more of an activist and conservatives are more of the restraint perspective. But you can be a conservative or liberal and be an activist at the same time. So ideology is involved. When we say a liberal, we're looking more towards the left, and when we're saying conservative, we're talking about being more towards the right on an ideological scale.